طيب السلام عليكم. Let's start again. Today will be the last lecture in contract. This is the fifth part of the contract. We're still talking about the ways and situations in which we can set aside the contract. Last time we had some situations like we having mistake by one party or by two parties, common mistake, and we did speak about misrepresentation, when somebody is making false statement and the second one can have the right to remedy or have the right to void the contract. Today we have to look at the incapacity. This is the case and situation in which we find incapacity. Incapacity is opposite of capacity. It's the ability. Capacity is the ability to do something, to not doing something. So incapacity, stop doing something. Incapacity, the non-ability of somebody to act, to make a transactions. The incapacity can be defined in contract as the capacity of somebody, capacity of a person to either he enforce contracts or have contracts enforced against them is restricted. Restriction, inability of somebody to make a contract. Any one of us can make a contract. Every day we can make contracts, and no one can stop you. As long as you have the money to buy, you can buy. Then you have the freedom to make the contract. Sometimes some people in some situations, they are not able to make a contract. Think about it for a few seconds. Think that some people cannot make a contract. Why is this? Who's the one cannot make the contract? Children, old people, mentally incapacitated? What do you think? We have some people cannot make contracts. They have no will. They have no intention. So if you have no intention, then your contract is not. It's void, as if there was no contract from the beginning. Then some people go on.
People who are mentally
Incapacitated.
either by disability or blindness.
If you look at children, for example, children may not be able to hold to bargains they have made. Child underage, they cannot have the intention, full intention, to be engaged in business. Children can buy things, they can buy, but things are suitable for their life. Children can buy sweet, can buy sandwich, can buy coffee, can buy something which costs money, which is suitable for their life, but they will not be able to make a bargain, to make a transaction which costs lots of money. We allow children to have deals, transaction, but those transactions they make suitable for their age, and those deals were in accordance with the reasonable price. Like a child buying sandwich from the canteen in the school, is that fine or not? Is that okay? It's okay, you can make it. He or she can make that transaction. But talking about a child, he's 10 years old, buying a laptop. Do you think he or she has the capacity to do so? No. A 10-year-old child will not be able to buy a laptop. Laptop costing $800. A child in that age or that age will not be able. So if we find a mistake here, if we find a situation in which the laptop the child has bought was too expensive, more than someone can pay for it, then we have to vitiate the contract. We can cancel the contract. We can get his money back. So contracts are not held to bargain, cannot stand. If the children, sometimes some children, like in Palestine, someone who's over 15 years old, over 15 and less than 18, can make a transactions, commercial transaction, but he or she would need a sponsor, someone to look after him, someone to work on his behalf. But someone is over 18, most likely he or she has the freedom to make any transaction in life. You can sell, you can buy, you can bargain, you can exchange, it's up to you. But children under 15, this is not a definite age. Some places they say under 18, some of them they say under 15. Those children under that age, we call them in English underage. Underage. تحت السن القانوني. They will not be able to function. They will not be able to make a transactions unless this is a transaction for their own benefit. And even if, like I have a child and he would want to cancel, or his father would like to cancel his contract, it's up to him. Because the child has no full intention. Same thing with people who are mentally incapacitated. Some people have mental illness. Someone cannot have a full intention. You know that people are mentally ill, they will not make transactions. And even if they do make a transaction, they are not going to be held to this transaction. They will not be responsible for this. Because if I would like to ask you for commitment, then you have to have intention. You have to have the mind to think. This is one condition. Intention is one condition. So someone was mentally incapacitated. Someone was drunk. You know what does that mean? شارب. سكران was drunk. Someone with disability, mental disability, mental. إعاقة عقلية. Those people cannot make any transaction. So in this case here, incapacity would affect the contract. Then this contract itself is called voidable contract. So anyone can void it. Any party of the two can void this contract. It's voidable. Why has it been stated? Why has it been stated by law that such categories of people will not be able to make transactions? What's the reason behind it? Why should we stop those people from making the transactions? Why is this?
Because I think that advantages, maybe they haven't the attention or
Yes.
to make this transaction, they not in this sense.
Okay, look at this point here. What's your name again? Dalia. Dalia.
When the law limits or bars a person from engaging in specified activities, any contracts to do so are either voidable or void for incapacity.
Okay, in such cases, the law bans or bars such people to make any contract. Then those people are not allowed to make such contract. This is by law. Those people are not allowed. If they do so, if they make this can be either voidable, the contract, voidable or void. Void, we understand the difference between them. Void and voidable. Void contract, it does not exist. Voidable, قابل للإبطال, which we can cancel. Why? Because we would like to protect those people. Someone cannot have full intention. Someone in a dire situation. Someone was sick. Someone was mentally ill. Someone was underage. Those people are or have to be protected by law. We have to look after them. We should not abuse them, because those people easily can be abused by others. Isn't it? They can be abused by other people. They can use them, take their money, take their benefit and goods. And this is by law. Such people, if they make any transaction, this transaction will be void or voidable. But sometimes we have one case, we have to stop some people of making transactions and make them having incapacity, not for their benefit, but for the rest of the society's benefit. Like insolvent, مفلس, bankrupts. the loan capacity can serve either one of two. The loan capacity, incapacity, can serve either number one, protect whom? Children, mentally incapacitated, but at the same time, it can be a way of restraining, stopping somebody to act. Why? Because restraining people who act as agents for others. Because some people are not allowed to act as agents. Some people have no authority to act. Some of them had authority in the past as agents, but now they are not. Then we have to stop them. They have no capacity. If I was working for somebody, for some companies, as an agent for the past 2 years, but today I'm not anymore. So basically, I don't have the capacity to act anymore because I'm not an agent. And another case, as I said, the bankrupt. Someone is an insolvent, muflis, will not be able to make transactions. He has no capacity. We have a situation of incapacity. Why? Because we would like to protect the society. Someone has no money. Someone is insolvent. This person have no money to spend. He or she cannot make a transaction. So we have to stop him, not to protect him, to protect the society from that person. That's what's called incapacity. Fine? Good. The next case, it's illegal. Illegal contracts. We have some illegal contracts, as you can see that. These contracts are void from the beginning, as if there was no contract. They do not exist at all. Contracts are void because they are illegal. How a contract can be illegal? It's a contract. We have offer and acceptance, we have intention, and we do have consideration. But this contract, which stands fine, has all conditions, this contract can be illegal. How? No?
It's based on illegal purpose or contrary to what is able.
Like what?
Like contract for selling weapons or contract for drugs.
Okay. Same.
If it's dangerous also.
Okay. Some contracts are not allowed. There are some transactions in our society are allowed, which is fine, accepted, but in other societies are not accepted. Some transactions in Netherlands, you know what Netherlands? Hollandia. Some transactions in Amsterdam, in Netherlands, are accepted by the law, by society. But in our society, these transactions are illegal. Like, for example, selling cannabis. Cannabis is one type of drug. It's not a drug even. Hashishu. It's called cannabis. This is allowed. Now it's allowed in some places like Amsterdam, in London, in the UK. You are allowed to smoke it, but you cannot sell it. I mean, if you smoke it, you can buy it. So this contract, it can be fine, but in our society it's not. To sell alcohol, it's allowed in European societies, but in a Muslim society it's not allowed. So it's a transaction, can be fine here or somewhere else. In the second place, it's not. It depends on the purpose. Here, contract illegal depends on. Go on.
For example,
No. Can just read the.
Illegal contract are contract based on an illegal purpose or contrary to public policy.
Okay, we have two cases. This illegal contract can be illegal because purpose is illegal, the objective is illegal, or it's against public policy. Against public policy. We have two examples, number one and number two. First example, a lady, she had her husband's checkbook and she forged signature. Signature, can you forge it? For tazwir. Forging her husband's signature, and she took that checkbook for his signature. She used to buy things and goods and commodities from the market and using the checkbook. After she was discovered, her husband went to the bank and said, well, okay, he signed a letter to the bank to commit himself to pay the bank all the money. Say, well, I will pay everything but you don't have to prosecute his wife. Then this contract he signed with the bank, he was going to pay the bank the money. He was going to pay the whole money, the whole amount. But at the same time, paying this amount of money, he would protect his wife. But what she did was illegal. What she did, forging signature, تزوير, جريمة مختلفة. It's a different type of crime. It's not. This is criminal law. It's not civil. It's not commercial law. What he did, he had the intention to protect his wife. At the same time, he has the intention here to stifle criminal justice, to stifle criminal prosecution, stifle and يعوق العدالة. This case, by what he doing, the purpose was illegal. You okay there? It's illegal. It's not. This is not the only case. It's not the only case. Like to sell weapons. It's not allowed. In our society, to sell alcohol, it's not allowed. By law, say this is a legal act. And it's not accepted. So by doing this, even if the contract was fine, we have offer and acceptance, intention, and the money was paid, and alcohol was delivered. But this contract is illegal because the purpose was illegal. Purpose here, we mean by this, it's the public interest, public policy. We mean the criminal law. It's something not accepted by the whole society. And the second case is contract here is against public policy. Like minimum wage, the minimum wage. How much money should somebody get once he or she works for a company per month? It depends. It depends what he does, what the company would be. It depends on the average rate in the country. But in all countries, usually we have something called the minimum wage, the minimum salary. In Palestine, we don't have something like this. I mean, it's not implemented. One of the lawyers was saying to me that the minimum wage in Palestine, according to the law, is about 90 shekels. حد الأدنى للأجور. The minimum wage, it's 90 shekels per day. Per day. Now, how many people in Gaza, how many members of the staff get more than 90 shekels? Many of them get less than this. Maybe 50% of the employees get less than 90 shekels per day. I'm not talking about public employees. Even if you talk about private employees, someone works for the company, someone works in construction, most of them get less than 50 shekels or about 50 shekels. It's under the minimum wage. In the United Kingdom, in the UK, the minimum salary was I don't know how much exactly now, but a few years ago it was £6 per hour. That's the minimum wage per hour, £6. And you work about 38 hours a week or 40 hours a week. So you will get this amount of money. Now, if we have a contract between the employer and the member staff, and this contract states that he will pay him only £4 an hour, is this contract legal or illegal? It's illegal. Why? Because even if I accept it, you have this condition saying, well, I'm going to pay you only £4 an hour. And I said, okay, I'm going to accept it because I can't find a job. It's the only employer can employ me. Then in this case, this contract is illegal because this is against public policy. There is a minimum wage. This is not the only case. We have many cases like this. Like public policy says about the food. Some types of foods are not allowed. Some types of food are not allowed. Like, for example, to buy chicken, live chicken, from China, to bring them to Gaza. You're not allowed to do this. Because this process is complicated, and you need the Minister of Health to check and to examine such. Are they fine or not? Do they have any sickness? We cannot find this ability, it's not based here, then in general such contract to buy a live chicken from China to bring them to Gaza is illegal. Why? Because public policy says you are not allowed to bring them because they might affect the health of people at the time in which the Minister of Health have no capacity to examine such chickens. By the way, the live chicken, they don't call them a chicken. The chicken is the one which is slaughtered, the meat itself. الحي, الدجاج الحي, it's called hen, isn't it? Yeah. Someone can read this for me? The first line, just the first line. Go on. Yalla.
Breach of contract is a failure to perform as stated in the contract.
We can imagine that this is the contract. In a normal situation, both parties have commitment. Both of them have to apply the rules and the terms. But sometimes we find one party, or two of them, maybe two of them sometimes, breaching the contract. If one has a breach يخالف, then the second party can have remedies. Breach of contract, it means simply that failure to perform as stated in the contract. Failure. If I was supposed to deliver you 70 chairs like this. See that chair here? See them? 70 chairs like this. And each one would cost 150 shekels. I would want them in a specific order. I want them with the handle, wood, so the student can use it to write. Isn't it fine? Now, if the factory delivers such chairs to me, perfect, but without the handle, without the wooden handle, then this is a breach of contract. It's up to me. I can accept or I can refuse. If one party has a breach, it is failure to perform as stated in the contract, I would have to do exactly as was mentioned in the contract, as the conditions and the warranties, as the terms and the contract. I would have to do my best, my responsibility, my tasks as it was written down in the contract between the two parties. If I cannot do so, this is failure. I could not make it. I was supposed to do something in accordance with the contract, but I could not. I failed to. If I fail to conduct my duties, my tasks in accordance with this contract, then the second party would have remedies. Then you're going to ask me, what does it mean, remedies? What does it mean? Anyone knows? If you would like to translate it, remedy, from English to Arabic, it means علاج. But in legal terms, it includes two things. هي علاج قانوني, yes. It's a legal remedy. It has two things. It can have money damages and it has specific performance. Two ways. Yeah, there are many ways to remedy breach contracts, assuming that this contract is not waived, hasn't been waived, it's still alive. This contract still exists. This contract, we have to uphold it. Then we have two ways. If Haneen has breached the contract, then Dahlia would have either two choices, assuming in this case that this contract is still fine. If you breach it, then Dahlia would have one of two. A has a breach, B would have remedies. One, money, compensation, damages, or specific action, specific performance. You have to do something, as we will look at it now. What do you think? Which one is more often? Money damages or specific performance?
Money damages.
Is it? Okay, yes. In most cases we have money people paying money, because it's most cases about money. You invest, you do business because you would want to make benefit, money. Now, typically, remedies is an award of money damages. But in some cases, money will not compensate people, isn't it? Sometimes some money will not compensate. You have to do something. You have to take an action. And you know that people sometimes will not accept the money. You want to compensate me, you have to make an action, not money. We'll look at this situation now. We'll see how often specific performance is the case. Let's look at the first one, number one. This is solution number one, option number one for B. A has a breach. B have two options. Number one is money damages. We'll look at it now. Can you see the line? Can you see it? Good. Go. Well, hold on a second. I know this is slide one of the most difficult slides. Too much information. Just be careful, look at it, and stay with me. We'll take it line by line. We have 4 types of compensations, 4 types of money damage. It's when I say money damages, I mean most likely compensation. تعويض, نظام التعويض. But how? Because we have 4 types. Number one, it's the normal, the usual, the often damage, money compensation here, compensatory damage. Compensatory. It's a compensation paid by A to B. Why? Because my action as A has affected B negatively. He lost money because of my action. B has lost money because of A's action. Then he would have to compensate him. Simple, isn't it? Giving to the party which was affected by the breach of the contract. This can be either, look at this, can be direct damage and it can be consequential. Direct, مباشر, and it can be sometimes consequential. It can be because of the action. I did not get this damage right away. It was later on, after a few weeks, after a few days. It's a consequential. So in this case, we have to be money compensation. Number 2 is nominal damage. It's something new for you. Nominal. What does it mean, nominal? It's the same like minimal. حد الأدنى. Minimal, nominal or minimal damage. This include Didi. Well, can you read it?
Nominal damages include the minimal dollar amount often
sought
to obtain a legal record of who was at fault.
When we say minimal, how much money would it be? I've seen one of the cases I was looking at, one of the cases between 2 football clubs. 2 football clubs. How much money football clubs make? Millions, isn't it? Millions and millions of dollars. And that the compensation was only $1. It's not a money. It's not about the money. In this case here, a nominal damage or minimal damage, it's to get something just to prove who was at fault. Was it? What's your name? Yeah, Summer. If it was Summer or was Anud, which one was at fault? I would have to look. I know that neither of them has lost money. You did not lose, and she did not lose money. But one of them has made a mistake. One of them has a breach the contract. It's not always that once you breach the contract, then the second party will lose money. This is not the case. Sometimes I lose, sometimes not. I want the second party to do his part as stated exactly. I don't want you to amend or to mix or whatever. No. Like for example, when I supposed to deliver the goods in 5 days time, but it took me 7 days time or 10 days time, it's my fault. But I know that the second party did not lose anything. In this case here, the minimal damage, we want just to make who was at fault. Who was the mistaken party? Why is this? Because in the future, this would be against that party. If he does it again, this might affect the second party badly. then he can ask for compensation. I mean, if you make the same mistake again and again, then the punishment will be multiplied. Then the first time you're not going to be money, but then later on you might be a hell of money for this as compensation, as we're going to see the next point. This is, so number one, compensation, because you lost. Number two, you did not lose. It's only to make sure that someone was mistaken, someone has a fault, was at fault. Third, punitive. Can you read it?
Used to punish the party at the fault possible in
fraudulent
situation.
It's called the punitive iqab, punitive damage. This one used to punish party, punitive party at fault possible in a fraudulent situation. We know the difference between number 2 and number 3. Look at this. Number 2 was a mistake. Maybe it was a lack of commitment, a mistake, no intention. But number 3, it's a fraudulent situation, deception, fraud, في غش, خداع. Then it's a punitive. We have to punish the party who was in a breach of this contract because he was deceiving the other party. Then you have to pay. Even in this case, he or she would have to pay the money, but this as a punishment, not as a compensation. No. Good? Easy? Number 4, Hánي. Exemplary.
Used to make an example of the party at fault.
Yeah.
To similar
Crimes.
Can be multiplied by factors of up to 54 such damages.
Okay, number 4 is exemplary damage. Exemplary is to make an example. To make an example. يعني نجعل الشخص عبرة للناس. To make an example of somebody. Exemplary damage. Why? Because he or she has breached the contract many times before. Then we have to increase the punishment. We have to multiply the fine. The money you have to pay, it has to be multiplied. Not $200. You have to pay $20,000. Maybe. It can multiply up to 50 times. And who can decide on this? Who can decide? Who can impose such fine or such a crime? Punishment? Judge in the court. Who has the discretion to impose such fine or such punishment or sanction, whatever you call it, on the party. And this can be multiplied in order to deter the others. As you could see now, these are 4 situations. 1, 2, 3, 4 types of damages. 4 types of damages. Now, sometimes there are some cases we cannot have the same damages or compensation. The judge cannot select any of them. He or she would have to take a different step. If you look at these cases here, number 1 to number 4, you find them based on justice, equity, and fairness. If the judge could not make his mind and could not match any of the cases with such damages, then in this case we have something called reliance measures. And is someone to read it there in the middle? What? Here. Okay, when it's not possible, sometimes it's not possible to award money damages for any of these cases. What can I do in this case? I have a case in front of me on my desk. I could not award any money damages based on these examples. Then I can take other 2 options. Number 1 and number 2. Can you see them? These are important here. Number 1 and number 2. I need someone to read them. I'm going to analyze them step by step. Go on.
Designed to restore the injured party to the economic position that he had occupied at the time the contract was entered or designed.
Okay. Hold on. Number 1 is this is designed to. This step is taken by the judge, and this step is designed to restore. بنعيد تاني. To go back. who's the injured parties, the one who was affected, the one who lost the money. What can we do with him? A, B has lost. What can we do? Then we have to restore him. How much? To the economic situation, position that he had occupied at the time contract was entered. بنرجعه للحالة اللي كان عليها وقت توقيع العقد. How much I lost today as B here, I would come back to the same time when I signed the contract. Then at that time, how much money I had, how much items I had, then I would go back, I will look, and then we calculate it, and then we have to pay that person. I have restore to go back. يعني بنعيده للحالة اللي كان عليها as it is. That's justice, equity. Or we can design to
prevent a breaching party from being unjustly enriched.
Or at least what we can do. If we cannot do all what we had here before, what we can do here, the last point is designed to prevent, to stop the breaching party. A breaching party, we have to stop him. Of what? Of unjustly enriched. Stop him from making money at my expense. Why he should get money out of B? We have to stop that person of making money unjustly enriched by this contract. So I know it's not easy. I mean, it's complicated, too much details here, but at least I hope that you understood. Have you? I think it's not bad. It's not that difficult, isn't it? So? Yeah. Not often that we have money damages. I mean, not always. Often we have money damages, but not in all cases. Sometimes people will not accept money. They will not get compensation. They want specific act to be done, specific performance to be taken. This is one of these situations in which the injured party would have to claim specific performance, not money damages. Now, there are some circumstances in which it would be unjust to permit somebody, which is the defaulting party, simply to buy out the injured party with damages. We cannot allow A to buy B by money. He might be rich, he might have some money, but we don't want his money. We want his action. We have many cases like this, especially this connected with people have specific skills. Like you want somebody, like a singer, for example, a singer. When you make a contract with a singer and a musician, and that person have specific skills, and you made a party, and somebody want to deliver a speech, and we invited people on a specific date to attend this conference or this party, and somebody come to make a speech because he is a figure, he is a public figure, everyone knows that person. Then he said, well, I don't want, I'm going to compensate you. Is that possible? It's not. Another case, like having a building a house, or building a tower. And I made a contract with a contractor, a مقاول, contractor. Then this tower will be built over 2 years. Will be finished completely in 2 years' time. 2 years' time. After 6 months, we have finished nearly about 30% of the building. But then the contractor said, well, I'm not going to complete it. I would not be able to complete this building because I'm busy doing other business. And if you would like, I can compensate you. Is that possible? You know, how come? I mean, how much money would compensate me? Because in 2 years' time, I will not finish. To find someone else to replace that person, it's not easy. To find a second contractor can take the same job, it's not easy. Because most of them would start from scratch. This is not only the case. Sometimes you find someone with specific skills, a painter, painting a building, and he just completed 20% and then he refused to complete. Then we have to force that person. You cannot compensate me, come on, because if I'm going to get someone else to do it, he will not. And then I would lose. my reputation, my name, my business. Many cases like this, we have to force the second party who is breaching the contract. We have to force him to make a specific performance. فعل محدد, specific action, which is you have to do what has been stated in this contract. We have the contract between two people, A and B, and they have to deliver. They have the commitment, they have the obligations. None of them can say no. In this case, if he or she says no, cannot do it, then we have something called a specific performance. And this specific performance can be only ordered by court. I cannot ask the second party to enforce the contract. It's not up to A or to B. This case, and only this case, only one can decide is the judge. Because this would affect the mentality, the physical side, would affect two people. It's not about money. Money, well, it can be solved between the two parties. None of them, neither A nor B, can ask the judge to force the second party for specific performance. No. Judge can decide based on the situation. Because sometimes, like, we cannot force Haneen to paint this room. She doesn't like. Okay, are we going to kill her? She doesn't want to do that job. But then the compensation will be multiplied. You're not going to only pay the compensation for how much I lost. No, you have to pay me for how much would it cost me for my reputation as a second party. It can be looked at by the judge who can look at this case. This is called specific performance. Require that contract to be performed. Asking that this contract has to be performed. يعني نؤدي العقد. The second case is called injunction. Injunction, it's opposite specific performance. Specific performance, asking you to do something, asking you to implement the contract. You have to do the contract. Injunction, it's not. Asking you to stop. Enough is enough, because your action would affect me badly. I cannot teach with the all noise outside all day. They're having that machine digging in the cement, having that noise outside this building. I cannot focus, I cannot deliver, I cannot get the quality. So asking for injunction, because if the action continues, then I would lose. I would get hurt. Then I'll get on all issues order known as injunction, that is a party refrain يمتنع from doing something that would breach the contract. Because I knew your action, if you continue the same action, then this action would what? Breach the contract. And how what do you call it? وقاية. Preventive measure. وقاية. Step taken it before anything, because I knew, I assume, I imagine, I expect that you, if you do that action, then you're going to affect me in a bad situation. Like, for example, I know my neighbor is building a house. He's building the house. But he's, building the house on my land. He's taken 0.5 meter of my land. I have to stop him. Because if he carry on building that 5 floor towers, then I will not be able to ask him just to move it from my land. The situation, defect the situation, it costs him too much money. Then I would have to stop that person from the beginning, not to do this action. That's what's called injunction. In both cases, injunction and a specific performance based on equity. Because even sometimes the judge cannot force someone to make an action. The example of the musician or painter, singer, contractor, many examples we have, the judge will not be able to force. If you refuse, no one can ask you. No one can force you. Even if you would like to make it, if you would like to deliver, you're not going to deliver as we want. We're going to lose the quality. I cannot force someone to teach here. Like, if I refuse to teach, no one can force me. Isn't it? I just can't stand or sit down or look at you and not talking. Such such case here, specific performance is based on the discretion made by the judge, who can decide if it's possible or not possible to have specific performance or to have injunction. I want just someone to read this here, this paragraph for me. Go on.
Moreover, the references to an action in equity may act as a bar to specific performance.
Yeah.
Those neither performance nor injunction are available as of right to parties.
Yes. It's not right for the parties. It's not A or B can decide. The only one can decide on this case is the judge. Only the judge. The procedures we're going to take. How can we take the case to court? How can we take it? Should we take the case straight away if we have a conflict, A and B? A has a breach. B would have remedies, either money damages or specific performance. If it was you, what are you going to do? If I breach the contract and you are the second party, what's the step would be taken by you? Complaining against me? Complaining to me? Taking the case to the court? What are you going to do?
First, I will complain to you. Then, if you didn't respond to anything, then I will take the case to the court.
Good. First, we can sit down, we can discuss the case, we see if it's possible to have a solution or not. If we cannot solve it, then we have two options. Two. Number one, it's called here arbitration, tahkim. Number two, it's called civil lawsuit, filing civil lawsuit, قضية مدنية أو commercial lawsuit in the court. To obtain damages for breach of contract, obtain here, or to obtain a specific performance, we can take the case as it is, take it on a file, and this file here, this is my case, this is my lawsuit. I can take it to court, complaining against the second party. Or I can go for arbitration, tahkim. This morning, I was listening to the news, I think last night, this morning. It was said that in Dubai, 40% of commercial disputes are solved by arbitration. 40%. Because in court, it takes a long time, civil lawsuit. It takes a long time and it costs lots of money. By arbitration, it takes only a short time, days, hours, weeks. And then we can have decisive decisions, final decision. Final. Then this decision of arbitrator can be applied, can be implemented, طبق, exactly the same like a decision which is made by a judge. We have a judge in the court, official, working for the government, and we have arbitrator. Anyone can be an arbitrator. I can be, as a lawyer you can be, as an accountant, as a medical doctor you can be an arbitrator. Yes. Then you have to look in the case in your field. Like if you have sometimes some engineers, and we have conflict between two companies about the cement. Is it good or not? The quality. And we take it to somebody who's a specialist in this. It depends on each case, but anyone can be an arbitrator. Then the final solution, the final decision is equal to the decision which is made in the court. The same. Yeah. Certain claims, but we have some certain claims, we cannot look at them. There are some certain claims are not non-arbitrable. Some claims, some cases, we cannot take them to arbitration if these cases are connected to public interest. There are some situations the case itself would affect the whole society. Then there is no arbitration. Then you have to take it to the court, public court. Okay? You might have a question like this in the exam. True or false? Can you read it? Go on.
Certain claims held to be
arbitrable
if they implicate a public interest that goes beyond the narrow interests of the parties Example, civil rights violations.
Yeah. Yes. Okay, not the last point here, in the enforced in the same way, manner. This arbitration judgment enforced by the same manner like the court judgment. However, then we said that this decision or this judgment by arbitration is a final decision. In public courts, if I don't like the decision by the first court, I can appeal to the higher court. But in arbitration, no appeal. فيش استئناف, خلاص, final. Because both parties, A and B, they can choose one person or two or three. They can choose arbitrator, both of them. We have the choice. Then his decision will bind us. We have to accept it. Then we cannot appeal against it. Say, well, I don't like his decision. No, I cannot say that. I have to accept it unless this decision here, appeal only. It's immune. It's immune. محصن. Here, immune from appeal. ممنوع استئناف unless this arbitrator's decision was irrational or was tainted by a fraud. يعني كان غير منطقي بتاتا. Or was tainted by a fraud. يعني في غش وخداع. واضح. In only these situations we cannot appeal against it. Otherwise, it's a final decision. In England, Wales, the States, we do the same thing here, as you can see. The same thing. The same, like the court itself, the court can take a decision. And this decision, it's not always final because we can appeal against it. May be enforced. The contract can be enforced by the use of a claim or by applying for interim injunction. Like, you don't have all the time to submit civil lawsuit. Sometimes you can go to the court only for specific action, small action. Like just يسموه إجراء. One step, one procedure. Take it just to force that party. I don't want to cancel the contract. Just want to force him to stop this action. I want to force that person to stop of selling sugar at this time because we have an agreement saying that he's not supposed to bring sugar to Gaza until the amount of sugar I have in my stores have completely finished. To prevent a breach. The breach here will not be adequate. Can you, Dalia? Anyone, it's alright.
A breach of a contract where such a breach would result in
irreparable
harm.
We have to go to court to ask for interim injunction. إجراء تنفيذي مؤقت. إجراء مؤقت. This interim injunction to stop, to prevent a breach of the contract because I knew from the beginning that this contract was applied. Then we're going to be faced with irreparable harm, damage, harm. في أذى لا يصلح. Then we have to stop it from the beginning. Irreparable غير قابل للإصلاح. Or
a breach that couldn't be adequately remedied by money damages.
Sometimes the breach itself, here, the breach could not be adequately remedied by money damages. I knew. Then we have to stop that person of doing this breach from the beginning. We have only 2 slides left in this chapter. I don't know we have time to finish or not because we have 2 students, 2 presentation ولا one? Where's she? One, are you not going to do it today? Who's the presentation we have today? Who's the presentation? Dalia? But you're not. Why not? You're supposed to do it today. You're not feeling well. Okay, that's fine. So we have only 1 presentation. Okay, that's fine. So we have 3-4 minutes. So we can finish. Then you have to be ready to make the presentation. There is something. It's called third party. Here, look. We have A, B. We don't have C. We did not talk about C yet, did we? The contract can be by 2 parties. Most likely the contract is signed between 2 parties, A and B. In some cases, we have third party. A and B have signed a contract. A and B have obligations. They have commitment. They have to make some steps, some tasks. They have to pay money. They have to deliver goods. They have to stop themselves from doing something when they breach the contract. Some contracts, we have a third party, which did not sign the contract, was not involved in striking the bargain, would have standing to enforce it. He or she, despite the fact that C did not sign the contract, he was not involved, but he or she can ask for this contract to be enforced, isn't it? How is this? Anyone, somebody did not sign the contract, but he's asking for this contract to be enforced because he or she will get the benefit. Some cases, contract is signed between A and B, but the benefit goes for someone else. Only parties to a contract may sue for a breach. Only. But sometimes a third party can sue in recent years. Like, for example, in the United Kingdom, in England, Rights of Third Parties Act. It's most likely like insurance, similar to insurance. Here, we have the insurance company and the taxi driver and the victim. The insurance contract is between company and taxi driver, but the benefit goes for the victim. I don't have many examples like this, but this is the easiest example, and we don't have much time to spend on this. I have to finish the last slide, but if you have any question, we can look at it. The last slide in this chapter, which has taken a long time, 5 lectures, it's called Contractual Theory. This is supposed to be at the beginning of the chapter, but which is fine if you can talk about it now. Contractual theory, the question of why. We ask the question of why. Why do we study commercial law? What do you think? Why do you study business administration? Anyone can tell me? How many of you is accountant? How many accountant here? 1. And the rest of you are? Business administration. Why do you study business administration? Do you like it? Is it? Okay. Anyone else? Why do you study business administration? Suitable. Was it the only choice for you? Was it the only choice? You like it? Okay, we have many answers for this. The same thing here. The question of why. Contractual theory is body. This body of legal theory that addresses normative and conceptual questions in contractual law. We look at the questions in contractual law, and the most important question is why. Always asking the question of why. We have to analyze. Why do we have commitment? This is the main question we're going to ask today in this slide. Why contracts are enforced? Anyone can tell me why? We have this contract was signed by me and Anud. Contract A and B, 2 companies buying 50 items for $50,000. Then I have to enforce the contract and she has to enforce it. 2 parties signing the contract, they have to enforce it. Why? Why should I enforce it? Benefit. Good. Yes.
To make the transaction illegal.
To make the transaction legal. Okay. We have many opinions. One of them said because of the benefit. Answer is the benefit. I get the benefit and she get the benefit. Both parties have benefit out of this contract. If you make any transaction in the market, you buy something, you get the benefit out of the item, and the seller will get the money, which is the benefit. Second scholar said, no, it's not the benefit, it's the promise. We enforce, I promise you, and you promise me. الوعد والعهد. We promise each other, then we have to fulfill this promise. And the third party said, the third scholar said, no, it's not. We enforce the contract because of the obligation. Because we have tasks, we have obligations. I have to. في التزام على عاتقي. And this obligation comes from the same contract. Then I have to fulfill. I have to enforce. I have to pay the money, or you have to deliver the goods. Obligation is one of the most important sections in civil law you can study. If you study law, you study obligations in one semester. It's a huge subject, 300, 400 pages. And it's in 2 semesters. You look at the sources of obligations, number 1. That's in 1 chapter, 1 semester, 1 book. And second semester, you're going to study the rules of obligations. Now, I am obliged to teach you. Why? Because I have a contract with the Islamic University and they pay me salary. Then I would have to teach you. And you have to attend the class as a student. Now, we have obligations. Obligations can come here. Obligations, most obligations in our life, most of them are contractual obligation. Most of them, we commit ourselves by signing contracts, by making promises. I promise to buy a washing machine today for 2,000 shekels from the Saqqa company. They will deliver the washing machine in 2 days' time. Then I oblige to pay the money and they have to give me the washing machine. It's a promise, it's an obligation. My obligation comes from the terms of this contract, the terms of the contract. These most likely are contractual terms. And sometimes the obligation does not come from the contract. Sometimes the obligation comes from the tort, comes from the action. I can make an action and this action can affect me. I can get benefit from the action I go for. I can get the benefit at the expense of someone else. Then I am obliged to compensate that person because I get the benefit out of him. It's kind of what we call it, that someone make me a favor. Someone building my wall, the garden. Someone giving me the money to lend me money. Imagine any situation like this, probably that we don't have much time, which is called here, unjustly enrich. I can sometimes unjustly enrich myself at the expense of Hani. I get some money, some benefit at her expense, then I would have to compensate him. I am obliged. I did not sign a contract. See, do you remember the example we have? The example of the sprinkler system. Someone did not sign a contract. Implied in law. Did not sign a contract, but I have to pay someone because I've got the benefit. This is not a contract. It's implied in law contract. It's a quasi contract. It's a quasi contract. Anyway, so we have in life, we have many types of obligations. Most of them come from contracts. By this, we finish this chapter, and next week, we have to look at chapter 4, which is Sale of Goods Contract, 1979 in the UK. That chapter will take only 1 week or maybe 2 weeks. I don't know exactly. We have to see how it goes. Thanks for your time. But we're going to have a student now. She will make a presentation for 5 minutes.
Good afternoon. Today I will talk about illegal contracts. Let's begin with the definition of illegal contracts. Contracts whose formation, object, or performance is so iniquitous against the law of the land or contrary to public policy that no court will intervention or enforce it. Technically, it's no contract in situation where two wrongdoers enter into an illegal contract and one of them takes advantage of the other. Law normally will not increase to rectify the situation. any legal agreement under the common law of contracts is one that the courts will not enforce because the purpose of the agreement is to achieve an illegal end. The illegal end must result from performance of the contract itself. However, a contract that requires only legal performance on the part of each party, such as the sale of packs of cards to a non-gambler, where gambling is illegal, will nonetheless be enforceable. A contract directly linked to the gambling act itself, such as paying of gambling debts, however, will not meet the legal standards of enforceability. Therefore, an employment contract between a blackjack dealer and a speakeasy manager is an example of illegal agreement, and the employee has no valid claim to his anticipated wages if gambling is illegal under that jurisdiction. Okay. Contracts is restraint of trade if proved to be reasonable can be enforced. When restraint is placed on an ex-employee, the courts will consider the geographical limits, what the employee knows, and the extent of the duration. Restraints imposed on a vendor of business must be reasonable and is binding if there is a genuine sale of goodwill. Under a common law, contracts to fix prices are legal. Agreements are legal if reasonable. Contracts which contravene public policy are void. Okay, so a contract is illegal if it involves doing something that is a criminal act or a civil wrong or against the public good. For example, it's an offense to sell firearms to a person not licensed to hold one. So a contract to sell firearms in these circumstances is illegal. A contract whose purpose is to get the party to break another legally binding contract that the party has made already is also illegal. Moreover, contracts which otherwise would be legal is illegal if its subject matter to be used for an unlawful purpose. So, if a firearms dealer were to agree to sell a firearms to a person licensed to hold firearms, knowing that the buyer intend to use it to kill someone, that contract would be illegal. Okay. Courts will not enforce an illegal contract. Money paid or property transferred under an illegal contract can't normally be recovered. There are exceptions, however. For example, where a contract is made illegal by a statute based for the protection of a class of people, a member of that class can get back money paid or property transferred by her or him under the contract. So tenant would be able to recover money paid to a landlord, which the landlord is prohibited by an act to collect. A famous example in the United States, in which the California Supreme Court refused to enforce a contract for payment of promissory notes used for the purchase of a company that manufactured drug. Thank you for listening. Any question?